His awesome. It's DJ Fees.
Oh my goodness, I apologize for that. Good morning, good afternoon, and good evening. I did not know I was on mute. Apologies for that. I can see chats are coming in. We can't hear you. We can't hear you. Thank you for telling us in good time. I can see Faye saying is joining us from Nairobi. Okay, and now I'm all good and clear, Evelyn. Evelyn Wanjiku, I'm good? Okay, now let's get this ball rolling. So it's our monthly webinars where we get to educate you about different aspects of Safaricom Sacco and how it affects you as the customer and how to maximize your potential as a customer. Okay, so as the month comes to an end, please tell me on the chat where you're joining us from. I can see a couple of people have already told me they're joining us from Nairobi. And how's end month doing? I know Kabona's coming here. How's everyone doing with that? Are we being financially wise as far as spending that bonus is concerned? Okay. So a little bit about Safaricom product I want to tell you about. Safaricom Sacco product is the corner loan. Have you ever used the corner loan? So the corner loan comes in handy when, as it says, mwezi kiwa kwa corner, when the month is at the edge whereby you don't see salary coming in anytime soon and you still have bills to pay. So we have redesigned the corner loan and reimagined it all together and redeveloped it. Now the limit used to be 100K. We've upped it up to 200,000 shillings. Okay. We know that the school fees are coming up in September. So corner loan is there to save us all. So please, please, please. What is corner loan, you may ask? As I said, it's a service, it's a product that empowers members who have emergencies to sort out by applying for a corner advance. Now you can do this through two avenues. Of course, the USSD, which is *345, and my favorite, personal favorite, the app, the SAF Siri app. This is a very convenient app. So log on to the app and you can be able to see your limit that you can be able to borrow against. Okay. Now go apply in the event of an emergency and prosper. Now, a couple of housekeeping rules before we get started. For anyone with questions, please use the Q&A tab. Remember, that's where we are getting the questions from. I can see Susan is saying, good evening. Okay, no, that is for host and panelists. Okay, thanks. I'm joining from Wajir. That is Ahmed. Paulo Pere is Brazzaville, Kampala, Nairobi. Yes, Evelyn, thank you for telling me you can hear me. So I was giving her housekeeping rules. So the housekeeping rule number 1 is that For those on Zoom, please use the chat box. For any comments, the Q&A tab is for questions. Post your questions there. Facebook, use the comments section so as to post your questions on Facebook. For the panelists who are joining us today, because we have a good panel coming in, please be on mute until you're called upon and put your videos off. And as usual, in staying committed with diversity and inclusion, a live transcript has been made available for anyone with hearing difficulties who has joined the call. You can access this by clicking the View Transcript tab at the bottom of your Zoom application under More Options. So this will allow you to keep up with this particular conversation in a more comfortable manner. So what is the conversation, you ask? Today we'll be educating you on the role of Cooperative Tribunal. Did you know that we have a tribunal? Do you know what the tribunal does? So that's what we're doing today. And Safaricom Sacco and the rights of you as a guarantor or a loanee, and also about the loan recovery process. So that's what we're tackling today. Our legal team and our Safaricom Sacco care team will be at hand to answer any questions. Remember, questions in the Q&A tab. If you put them on chat, there's a high chance I'm going to miss that question. So put them on the Q&A tab, and the Safaricom care team, together with our legal team, they'll be on hand to answer all your questions. So don't shy away to ask, okay? Just ask the questions and we'll be there for you. So to get us started with this, I'd like to introduce Haigai Chimei. Now, Haigai Chimei is from our legal team. So what his job today will be is to take us through the role of this cooperative tribunal. Haigai is an advocate of the High Court of Kenya and practices under the Chimei and Company Advocates. Haigai, are you there?
Yes, I'm present. Thank you for the introduction.
Yes.
Welcome members and new members for Safaricom Sacco and any other one joining. What I'll be taking us through today, I'm joining you for the first time in terms of the member education. I'll be demystifying the loans, what are the roles of the guarantors and the terms with regards to the loan taking process. And after that, I will also have to briefly talk about the issue, or rather the role of the Cooperative Tribunal and what members need to know in terms they have any grievances regarding that. So I can request we go to slide number 1. My name is Haigai, as we have already been introduced. So our presentation today is divided into 2, and we are looking into the issue of demystifying the loan SACCOs. And when we were called upon to make this presentation, members had the questions regarding the issue about the guarantors. That is the main issue we'll be looking at. What is the role of the guarantor? What are their rights? What are their duties? And vis-a-vis the loanees, and also vis-a-vis the roles and the duties of the SACCO. So as we'll be going through this presentation, we'll ask all the members who have joined this dialogue to have their questions ready. I know you have 1 hour, but if you'll have any other questions over and above this session, we'll always have time to share with us or read through the SACCO, and we'll always have time to respond to it. So I'll start with the main presentation being that what are the rights of a loanee and their duties. And the first right that you'll have between a right, can I just go back to the first slide? We'll have first, before I go to the rights, let me talk about the anchoring, or rather the basis of what the law provides. And the main law that regulates SACCOs and cooperative societies in Kenya is Chapter 490, Laws of Kenya, that is the Cooperatives Act. And after that, what that act provides, or rather what it calls for members to do, or what the SACCOs are supposed to have in the regulation of their respective SACCOs, we will have the SACCO policies, or rather we have their bylaws, and then after those bylaws, we'll have policies regarding which sector they're dealing with. But today we'll be looking at the Sacco bylaws together with our credit policy, because that is where the guarantors' roles and duties will come to. And then after that, you can move to the next slide. Under this, what we are looking at, what are the duties? What are the duties of a loanee? What are the duties of a loanee in terms of the process whichever they're going to apply for the loan? Of course, all the members, I assume all of us, we are here, we are members of the Sacco, we know why we come for these loans, but in as much as by the time we are coming to take these loans, you have a need somewhere, you have something pressing. I know the Sacco offers you an array of a number of products that would always meet your needs. But even before you do that, there are also Sacco rules and regulations, what I would want to call for today. Those are the bylaws. The bylaws will have to regulate the credit policy in terms when they're giving you those loans. And regarding that, you as a member, you always have also your rights. Under the legal rules, or rather in law, there are rules, there are rights and there are duties. So you're taking a loan, you have a right to that loan, to the extent that if indeed you qualify, you'll have to be granted that loan. But you'll also have a duty which is corresponding to that right, that you've taken this facility, you have to repay the same. So, and what is also the other an obligation we'll be looking at, before you get to that point where you're being given this credit facility or this loan you're taking from the Sacco, you will have other security that the Sacco, or rather the credit policy says. What is the security? It is either you offer something which is immovable property, that is for people who will be taking loans regarding using their title deeds, maybe logbooks and any other collateral that the Sacco may have their hands touched on. Or in the alternative, the Sacco also provides for instances where members or rather colleagues or members in the Sacco will have to guarantee the others. And this one will always guaranteeing the other member will have to go to the extent that the limit that you can guarantee will only go, or rather is only commensurate to the shares that you hold within the Sacco. So you cannot say, or rather you can only guarantee to the extent that you will hold, or rather the shares that you have. But to that extent, what we'll be looking at, number one, what a member needs to understand, number one, that you'll have a right to information. A right to information is not only a part and parcel of the bylaws, but that is a right that is also anchored in the Constitution of Kenya. You'll have to make sure that you'll have to be complying with the loan terms, which at the application stage, of course, the Sacco will have to send you the loan terms. You'll have to look at it. There is also the duty you'll have to be looking at, that I'm applying this loan for a specific purpose. And is it the specific right, or rather the specific obligation that I'm going to use? Because most of the time you'd find members who would take facilities that they will have to misapply the loan. And if indeed the loan which was advanced to you, maybe it was for development purposes, and you had maybe projections and telling the Sacco that, look, I'm starting a business and I want to set up this. If you divert those funds, then to the extent that one day or one time you'll not be in a position to pay, you will not be able to go back to the Sacco and then plead with them, because when we'll be making this presentation at the latter stage, you'll come to see that when sometime when there will be default by either the loanee or maybe any other member, you would have the chance, and what the bylaws would allow you to do, you would even go to the Sacco, and the Sacco would allow you maybe to restructure your loan in such like instances, depending with the times. But if indeed you had to maybe divert those funds to another project, I think you'd be caught hands down. There is also another a duty that for the loanee will have to, is that you need to make sure that there is proper maintenance and for that security that you are providing. Let's say, for instance, your security that you're providing is a title deed. You need to make sure, let's say maybe the title deed has some developments on it, or maybe some structures on it. As a loanee, you need to make sure that the value of that security is not deteriorating at any time, or at any time at all. So the most important thing, you need to make sure that as you applying this loan, the Sacco's rights, now, what is your right? Corresponding to it is the duty to the Sacco. And what is a duty to the Sacco is a right to you. So it is always corresponding to the other one. So the other one you also need, or rather you are entitled to, you have a right to information, to loan repayment, or rather that's a duty to you to early loan repayments. For each and every product that you'll be getting in terms of your loans, you'll always get the timelines to which you are supposed to be repaying the same. And the most important thing is also you have communication with the society. In case sometime maybe you've said I'll be repaying my loan on the 30th day or 15th day or maybe the 20th day of the month, there is no maybe communication or rather maybe any monies that are coming. You have a duty to tell the Sacco that, look, I have not done this and this because maybe my projection in terms of my finances, because Safaricom Sacco has members from diverse backgrounds, is not only employees. So maybe a business person, he has not gotten his payment from somewhere and something, that you have a duty to inform the Sacco so that the Sacco does not start exercising its rights on the other end. And then the most also important is that the compliance with the law. What does it mean with the compliance with the law? You need to make sure that this loan first is being applied in a lawful manner, because at the end of the day, if indeed you have applied for this loan and you have said, for instance, I'm going to spend or I'm going to utilize this loan for X, Y, Z, or in the other or in any other manner that that member would wish, the most important thing for the Sacco that we'll always want to do in the first instance is, has this member complied with what? Because under the law and in Kenya generally would not, in the most of the instances and even in banks, they would always ask you first, what is the source of this money? Because now you could not be taking maybe illicit cash and maybe putting the same within the Sacco. So the most important thing is, that was just like an example. You need to make sure that whichever activity you are doing or whichever action you are taking with regards to the funds will fall within the four corners of the law, and that means that should be legal. So you are not taking illegal or illicit money, a situation where ethics and anti-corruption commission will have to come in. So you need to make sure that these funds that I'm obtaining, they're legal, and I'm putting it for a legal purpose, so that you're not taking this money for other illegal activities. So that is a duty to a loanee. And then the last that we have on this slide that we're looking at, as a loanee or as a loan borrower, you need to make sure that you have proper records for your loan. Most of the time when we are under pressure just to take loans, we always take it, but sometimes you do not want, or rather you forget even just to keep even the e-filing records or any other soft copies. I would want to advise each one of us that is listening to this training today, that it's always important for each and every one of us to ensure that for each and every loan that you're applying, because you never know about tomorrow. Sometimes maybe it's you whose rights would be maybe been violated, or any other right, because in a loan situation, particularly where we have securities, and in this regard, I'm looking at various forms of securities, including you have the shares, you have guarantors, you have other members' deposits. So to that extent, you need to ensure that for each and everything you are doing and you are communicating with the Sacco, you need to make sure that at least have those records in place, just for the rainy days, as I would call it. Let's move to the next slide. We also have the duties to a guarantor. And a guarantor, in this instance, I don't want to assume, a guarantor is this one person that will stand in as a security. You don't have a title, but you want a loan. Maybe it's a small loan. Your friend or a member who is also can come and stand in for you. The Sacco will allow that guarantor as a security on your behalf. Let's say it's a loan for 1 million. You have one or two friends who can guarantee you 500,000 or maybe 200 on whichever shares they are holding in the Sacco. So the most important thing that for the guarantors that you need to ensure that you are looking at, there is the right to complete and the accurate information regarding that. Sorry? Someone talking?
No,
Host, is someone
we're
talking?
good.
Someone talking?
There was no one talking. There was no one talking.
Okay, okay, okay.
Yeah.
So the rights of the guarantor in this case, what we are looking at, we need to ensure that for each and every person who is guaranteeing the other one, you need to ensure that you know about their financial status, their financial health, if you want to look in terms of the financial balance, or rather language. So before you guarantee anyone, be it a friend, be it a family member, you need to ensure that for it or for them, you know the first the financial muscles and what they are going to do the loan for. And number two, there is also the right to fair treatment. And to the extent of the right to fair treatment in the terms of the loan application is each and every person will come to the Sacco applying for their loan, and it's the credit policy, or rather the credit committee, that will have to guide all this. And for each and every member that is applying, will expect at least a minimum, or rather a bare minimum of treatment from the Sacco. And to that extent, the most important thing that the Sacco would be looking at, and in terms of those who are even taking their loans together with even the guarantors, is a fair treatment, to the extent that I'm applying my loan in February, and I'm looking at maybe a turnaround of 14 days, be it 15 days, depending with the kind of security that the Sacco is taking. I understand the Sacco would take a while for them to process those loans that are using security for immovable properties. And it would be it should take a while, because for any movable property, and in this regard, I'm talking about title deeds, it will take a while, because it is upon the duty of the Sacco to go and register a charge on that property. And that process would take maybe perhaps 1 month and a few weeks on top of it, depending on where that title deed is treated. So, and the Sacco would not have to disburse that loan before that process is done, because for them, they're also bound by the legal rules, which is the bylaws and the credit policy. And then also for the loanee that is taking the loan, would also want to make sure that, in as much as they're taking, and for those who have a good faith basis, that in as much as they're taking this loan, there is a security for the Sacco to fall back on it. That one, it's very necessary. And there is also in terms of doing all this, and the rights of the guarantors and the rights of the loanee, you always need to make sure that the information that is being collected and being provided is being handled in a private manner. There is the Data Protection Act right now. There is also the Office of the Data Protection Officer. And in terms of any breach right now, the government is really reining in on those, let's say, institutions who are sharing information without the knowledge of those who have given the information. And in this regard, to the extent that the loanee is applying, or rather the guarantor is applying for this loan, we'd always want to make sure that the details, or rather the information that are giving to the Sacco, is always handled in a private and confidential manner, to the extent that they have allowed the same. So you're not expecting that today I'm applying for a loan, and the next time I'm finding myself on Twitter or on Facebook or any other place, or my name is being used for any other purpose without my consent. And then, in terms of looking at the rights, and then also the duties of both the loanee and the guarantors, there is also the duty that what is the fallback, or what does the law always apply? They always say equity will not suffer wrong without a remedy. We might have planned for all these things with the Constitution. You are looking at the Cooperatives Act, you are looking at the bylaws, you are looking at the credit policy, and any other policy that you'd have at Sacco level, together with also at the national level, being just the laws of the land. What happens in terms when now your rights have been violated? What are you supposed to do? The law will allow you to seek legal redress, and that will be our second part of the presentation. We'll have it in the second bit of it. Once we have already finished this, it is just today, and I will explain to members, or rather describe to members, what they need to know, particularly the role of the guarantors and the rights of the loanees to do all that. And in also explaining that, I will also expound on the role of the Sacco, because when I started, I said for a right, there must be a corresponding duty. So for what is your right, you should know that there is also a corresponding duty for the other person to do it. So I think the law, what I would just say is that the law will always have redress for any wrongs committed or for any action that has been violated in with regards to whoever says that this or the other action has been breached or any right has been violated. I could ask that we move to the next slide. We are looking at the duties of the guarantors, of a guarantor, or rather the duties. I think I touched this when I was also looking at the duties and the rights of the loanee. But just to go through is that before you guarantee any individual or before you guarantee anyone, just make sure that first, not even the legal bit of it, you understand their financial health position. You don't want to guarantee anyone whom you know is sick financially, not in a physical way. I'm saying that this is a person with a consistent cash flow. This is a person who is employed, and even if they're employed, they have a salary. And even if they have a salary, this salary is not attached in any other ways because there has been a habit where and it's good for members to know that there has been a habit which has been cropping up in Kenya that yes, you'll guarantee friends who have salaries, but after guaranteeing them, that's when you'll come to realize that they also have other loans which have already attached the whole salary. So you find yourself in an awkward situation that you have a colleague in your office and they're the ones who are putting you in a mess financially. And when the Sacco will come down raining on your shares, I think it will not be good for you. So the most important thing is the financial health, and then you also need to understand the terms and conditions of the loan. Each and every person who will be applying for that loan, before you sign any loan for any person, be it a friend, be it a family, be it a colleague, any other person, just make sure that you understand the terms and conditions of the loan. And most of the time when people are applying for these loans, they never even ask for about the policies that exist within the Sacco. The Sacco has an obligation to give you this information if you ask for it. Sometimes it will always be provided on their social media or on their portal. But I always request for anyone who can read, you always have to have time to go and read. Because if you are guaranteeing anyone any amount for me that is more than 5,000 or 10,000, you just need to have 10 minutes to look at what the law provides. Because these conditions are the same conditions which will bind you down. Then you'll come back and then ask the Sacco, why are you attaching X, Y, Z, or why are you doing this? And then number two, about the assessment of the credit worthiness, that is about the health. And then number three, you need to know that you are the security for the loan advanced. That is very important for the guarantors to understand this. When a member has been guaranteed by another individual member, it is your shares which are the security, not any other person. And that obligation cannot be wished away. You've signed under the dotted line. And the most important thing is you signed without coercion. And when you look at the terms and conditions of the credit policy that you'll be signing, and even the loanee that you'll be guaranteeing, there is nowhere that it says that you've been compelled to guarantee any other person. So the moment you put your signature below the dotted line, you're up for grabs for any other person, or rather for that loanee. You will always be bound together until that loan has already been exhausted in terms of repayments. So it is very important for members to understand that the moment you guarantee anyone, be it any amount, you will always be bound, or rather your liability or duty will extend to the limit to which you guaranteed. I have 1,000 shares, or I have 50,000 shares in the Sacco, and I say I only want to guarantee this member 100,000. You will be bound to that extent. You will not say that in the mid of the loan repayment, I am tired, I want to walk away, or I want to replace. Yes, the law allows you to make an application for you to be replaced as a guarantor, but there are conditions to it. You must find, or rather the loanee must find, a replacement for that security. So if it's an individual member who has come and you have already been guaranteed, or rather you've been guaranteed by any other member, and then let's say, for instance, you've guaranteed 50,000, or let's say 500,000. This loanee pays 100,000. You had already guaranteed 500,000. The balance is 400,000. So you cannot say, I'm tired. This gentleman or the fair lady has refused to pay. I want to cease being a security, or I want to cease being a guarantor to that person. The law does not allow that. So what is your recourse to that extent? You must make sure that the loanee, or rather the borrower, has to look for an alternative security, be it movable property being land, a house, or whichever, an unmovable property. If it's movable property, we are looking at the issue of the logbooks and the motor vehicles. So if he can bring in another security, which will be perfected at his or her own cost, then the Sacco will not have a problem from relinquishing you from exercising those rights. But if indeed that obligation wants to be taken away just for the sake of it, you are looking at it, the gentleman XYZ is defaulting, and the way things are, he's not going to repay this loan at any other time. The Sacco is not going to relinquish you at that point, and it's legally, it's both in the bylaws and both in the act. You cannot just walk away as if nothing happened. You guaranteed this person. I would call it, most of the time I would always want to say this is a marriage, and before you are granted a divorce, there are issues which must be determined. You don't just walk away at will. It's the court to tell you, okay, this has broken down to this extent, but for the Saccos, or rather for the loans, to the extent that this amount must be paid, you will always be liable to that extent. So going back to what I had said initially is, you always need to make sure that this person you are guaranteeing, this is an equivalent of a person you'd be spending time for the rest of that loan. If it's 72 months, just know that I'm not going to get in bad books with this gentleman or the fair lady, because before you sign, you have no obligation. No one will be looking for you when you haven't guaranteed anyone. Or in the alternative, if that is not okay for you, then you just need to look for immovable properties in terms of when you are guaranteeing the other ones. So I think I've done that. And then the last point being that you will always be held jointly and severally. That means that you have not paid, the loanee, or rather the borrower has not paid, he has that obligation to pay. But if he doesn't pay, both of you, jointly and severally, individually and all of you together. So the loanee has not paid, he will be followed up. But remember, before you even start following up on if the loanee has refused to pay, what do I do as a Sacco, or what does the Sacco do? We will have to go back to the security, because security just means the insurance that the Sacco has if you have for the loans that they are giving, that indeed at the end of the day this money does not belong to the Sacco. And that is the most important question, or rather the knowledge you need to have. This money does not belong to Safaricom Sacco. This money belongs to you members. So it is through collection of all these shares, deposits and shares contributions, that you are able, or rather the Sacco is able to give, or rather advance this money to the other person that are at that lower rate, because the rates cannot even be compared to the commercial loans. So when you are defaulting to that, it means there are people who will not be paid good dividends. So the most important thing to stress here is that once you have already guaranteed anyone any loan, that obligation does not walk away, or by mutual consent or otherwise, it does not walk away. The only time it walks away, or it can be taken away, it's if, number one, there is consent between the loanee, the guarantor, and the Sacco. And the Sacco says, regarding to this extent that we have gone, this security that we have already held, or we held at the initial point, is enough to satisfy the loan that is still in place. But before that is, and it's not mandatory that the Sacco will allow that, because for any financial or any other institution, or this is a cooperative institution, is it will always want to make sure that all the loans that have been taken have been repaid. So it will not want to relax any rule. Or in the alternative, the loanee, or rather the Sacco borrower, the loan borrower, will come and say, I want you to release person XYZ from being my guarantor, so that you can take this security. I think for that, I would we can move to the next slide. We're also still looking at the slides. I can see. I think I've already talked about the rights of a guarantor in just generally, but we can go back to we can go next to the issue of the loan recovery process by the Sacco, and what each and every member needs to understand or what needs to know regarding this process, because this is where now the rubber meets the road, because the most members would not understand this, and then maybe maybe for lack of explanation, one would say, okay, there was never told about this, or I was never told about this. All this information is always for the information that is not in the loan application form. You'll always find it in the credit policy, or you'll always find it in the bylaws, or if not, you'll always find it in the act. So this is a hierarchy of laws that is going up. You are looking at the policy, you are looking at the bylaws, after the bylaws, you are looking at the act, which regulates cooperative societies, and then you're looking at the constitution, because for each and every breach of right, you will always have a recourse to it. And we'll still talk about that. So the first, when we are looking at this recovery process by the Sacco, we are only, for this section, we are only limited to the issue of the Sacco. So what does the Sacco do when there is an issue about the loan recovery? By the time you hear that there is a loan recovery, things are bad. But to an extent that the obligation, or rather now the duties of the loanees are not being met. This person you guarantee that refused to pay. Number one, the first instance, what will happen is that there is a first notice that we will always send to members who have been installments in arrears. That one we are always talking about, of course, the loan borrowers. We are looking at the day around 30 days, requesting the members, and because I've been dealing with Safaricom, and we've been helping them to do recoveries in terms of some defaulters and others. They're always very relaxing in terms, in fact, even they are low. Sometimes they would even give more than those 30 days that you are seeing, that you've listed in the slides. They're always very understanding to that extent that you are giving them a call, explaining to them, this has happened, this has happened. All of us have been hit by COVID. During COVID, there were very many loan defaulters, and I know Safaricom grappled with this. But I was very happy to see that the board would even consider most of those pleas that would come. It was not only Safaricom Sacco, because most of the people were not even getting an income. So the law provides is 30 days, yes, but Safaricom Sacco has been very, can I say, gracious with their members in terms of giving them lots of time. It could have even gone more than 30 days. But if there is also failure, the first instance, the first notice, you would have to deal within the first 30 days. But there is always failure sometimes. Sometimes we'd say, okay, you've been given 30 days. The member undertakes to do this and this, and some members would say, there are those who have genuine concern that yes, they will not be in a position to pay within those 30 days, requesting the member to the notice for the 30 days, requesting the member to make the installments within 14 days. There are those who would come to the Sacco and then they will tell the Sacco, yes, my installment is of 50,000. I've not been able to raise the 50,000 because maybe I had a job, I was terminated and all that. I have, instead of 50,000, I have 40,000. You will have to sit down with your Sacco. It is your Sacco. Safaricom is a Sacco. You need to approach them. They need to know that your position or your financial position, because at the end of the day, if you don't cooperate, it means your guarantors are the ones who will have to suffer, or your security is what we will have to suffer the consequences. So lack of communication, you are going back to the rights and duties of which I introduced. Information and communication is always very important when you're looking at that. If there is also failure, there is also another, after the 30 days notice after that, the matter now starts escalating. There is a demand letter that will be issued by the Sacco. We have not even come at the advocate stage. There is always a 30-day a demand letter that will always be issued by the Sacco. The Sacco will, the contents of a demand letter will just be telling you that your person XYZ, you are our member, you applied for this loan on these following terms. The term of the loan was this, the following arrears, the arrears are already due, X amount of money has to be paid. And a demand must always have, a demand letter must always have that demand. If I would copy the language that we use in terms of the law, that there must always be have a demand and timelines. And what are the timelines that have been enshrined in this? We have 14 days for you to make the payments, or if not, we are going now, the guarantors now need to know that it's getting worse. And getting worse in this instance is the Sacco has tried all it can do, but the money is not being recovered. Now we need to tell the guarantors, because that is the security, or rather the Sacco has that security, just to inform the members. And then after that, they will always be given the 30 days is the notice, but for any demand letter that is legal in nature, most of the time, if you're within Nairobi, you'll always be given the 7 days. If you are outside Nairobi, you're given 14 days. And outside Nairobi means even diaspora. So how that letter will get to you, even if it's by WhatsApp, email, or any post mail, the 14 days will still stand, because that obligation that I talked about up there when we were starting on the introduction will still stand. And then after the expiry of the 14 days, now your guarantors now will have to face whatever the music that will be there. It is now their shares now to be recovered from.
Hello, Hagai, are you still there? I think we've lost connection. While he is trying to make his way back, I can see he's back.
I'm back. I don't know why it dropped.
You're back.
Okay.
Okay.
So
Take it away.
I think, let me take it. Yes. The issue of when there has not been compliance, and even the guarantors, because the guarantors, the most important thing is that the moment you get that notice or notification from the Sacco, it's always important, and I'm still stressing on the issue of communication. Always approach your Sacco and ask them what can be done, because there are other instances where even you as a guarantor, you'll always be in a position to help the Sacco also help you, because now that is the Sacco to help you there, because it's your shares which will be taken. You can approach the Sacco, tell the Sacco that, look, this gentleman has XYZ, or is doing this and this. What can I do to help? So that if you can put pressure on your loanee, or rather the borrower, then it's up to you to do that. And if the loan is not cleared, of course, what will just happen, of course, the loan will have to be taken, that obligation will have to be borne by the guarantors. What happens once that loan has been taken, or rather has been borne on the guarantors? Your shares are deducted just automatically like that. It might look simple, but in terms when it comes to the financial stress that comes with it, and then the mayhem that is attendant to it, it might not be good for all of us, because everyone joins a Sacco for purposes of those rainy days. Everyone joins a Sacco that they'll be able to take loans. Everyone joins a Sacco just to help them economically and all that. So the problem that will come is you've guaranteed someone, he's refused to pay, the Sacco has realized its rights, and then now you're in a position where you can no longer even take loans. You're not earning good dividends from your savings, and then now maybe the only person you'll say maybe is a bad person is that person who you guaranteed. But unfortunately, sometimes from our experiences, the person you've guaranteed, you might not even be bothered about that. They might be dealing with some other issues, maybe which are more important than what you did for them. So that still goes back to what I said. Always make sure that the person you're guaranteeing is a person who can take a bullet for you, and even for you, and in the return, the same can be done for you. So in terms of that, it always causes most of the matters, and I will tell you, 70% of the matters which go to the Cooperative Tribunal is the issue of about guarantors and people who have just refused to pay. Because for Safaricom Sacco, for them, they have taken your shares, and then now you will always have to go to court. And number two, there was also the procedure where the Sacco but that is not an obligation that the Sacco has. In the other instances, the Sacco will have to take even that loanee to court just to help the guarantors to recover this money. But it's important for the loanee to and the guarantors to know that the moment the Sacco has already taken those shares, the Sacco is not obligated to go and follow up in the issue of the default. It is you, the guarantor, that have that obligation. Most guarantors will always ask, what am I supposed to do, or what the Sacco is supposed to do? It's you, the guarantor, that has now that obligation to make sure that is either you're going to court, or you are going to follow up individually or personally to that loanee to make sure that they are paying. So the law will also allow, if a guarantor has, if a loanee has taken a loan, he has refused to pay, your shares have been deducted, you have a right to go to court. But also in the reverse, or rather in the same line, The Sacco can also help you to do that recovery. But at whose cost? That is always the question. But in terms of Safaricom Sacco, there's some of those loans that the Sacco has also tried to help members, because you'd always find that very many members are now facing the same challenges. The Sacco has been taking up the issue of now going to file cases of even on behalf of the members, or rather on behalf of the Sacco, just to make sure that the loanee is living up to their duties and make sure that that loan is being recovered. And if the Sacco manages to recover that loan from the defaulter, now those shares will have to be credited back into your account. But the problem with the challenge that might come with that is sometimes the process in court might take a while. So you might imagine, like, maybe for 1.5 years or 2 years, you are not in a position to take loans or such like instances. So that is very important for members to understand. And there are also issues about the CRB listing and such like attendances. But of course, there are also, this is just in law, but we understand that there are also other presidential directives which have been given some people to be removed on the CRB listing. CRB listing is just to make sure that you are not taking any other loans elsewhere, so that you already know your credit policy and that. So I think we can move to the next part, to the next slide. Now, on the next part of the presentation, I would want to summarize this, not even just moving in the form of the slides. The most important thing is, if I recap, you have your rights, you have your duty. Where you have a right, the Sacco has a duty. Where the Sacco has a duty, you have that right. Is always corresponding. So someone has taken a loan, you've guaranteed them, they have defaulted, your Sacco have already been attached. What do you do? That is the most important thing. You need to understand. You can move to the next slide. So we are looking at the establishment of the of the Cooperative Tribunal. This is a tribunal. A tribunal will always it operates like a court, but sometimes it has relaxed rules. So sometimes they will not be very strict in terms of the rules and procedures. And the most important thing that members need to understand with regards to the issue of the tribunal, even individual layperson, of course, you are not an advocate who has been admitted, or rather you don't practice the law. You can even represent yourself. But even if you are representing yourself, at least there are those there are also those basic minimum that you need to do. You need to know what is supposed to be filed and all that. So, but the most important thing is that the composition of that tribunal is, you have a chairperson, you have a deputy chairperson, you have an advocate who has been nominated by who has been nominated by Law Society of Kenya, and then other 2 members from the cooperatives from the commissioner's office, the cooperative commissioner's office. They will always be sent to the cooperative tribunal. For a quorum at the cooperative tribunal, they will always sit 3 members. For any hearing to proceed, there must be 3 members. So, and then how the cooperative tribunal is operated is it does circuits. So, but the most predominant one is Nairobi. Nairobi, in a month, they will always have like 2 weeks. And then the other weeks are always shared between Mombasa, we'll have Nyeri, we'll have Embu. Sometimes they would not sit Nyeri, and then they would go to Nakuru, they would go to Kakamega, they would go to Kisumu, and then Eldoret. So in all those circuits, it means if your matter was heard in Mombasa and maybe you filed your matter in Mombasa, you'll always have to wait for that circuit to go there. And the way I've told you is a month has 4 weeks. So if 2 weeks are spent in Nairobi, it means the rest, Kakamega or Kisumu. So you'll really have to wait maybe even for 6 months for your case to come back. But what is the benefit that you'd have being a Safaricom Sacco member? Safaricom is based in Nairobi, so the jurisdiction of these matters, most of them will always have to fall within Nairobi jurisdiction. So your matters will always be filed here at the Cooperative Tribunal. Where's the Cooperative Tribunal located in Nairobi? At Reinsurance Plaza, 11th floor. When you go there, we practice most of the time with the court clerks who are there. In case you need any information, don't always feel that you have to look for an advocate. You can just walk at the Cooperative Tribunal, help them, ask them, okay, I have this problem, this and this and this. They will tell you, okay, you have this, you need to file the particular documents which I'll talk about. So I think we can just move to the next slide. As we are also moving to the next slide, you need to understand that any disputes, or even before for the role, any dispute that is between a member, a former member, between or regarding the business of a Sacco. It is captured under Section 76 of the Cooperative Tribunal, which is Cap 490 laws of Kenya. That dispute has its jurisdiction, or rather, the only person who is competent to handle that dispute is the Cooperative Tribunal. Very many advocates make the mistake of just rushing to court. The moment you rush to court, to the normal civil courts, that court does not have jurisdiction. And jurisdiction means, do you have the power to arbitrate on this dispute? If you don't have, in law, your case will just be thrown out. And it will be very sad if indeed maybe you came for this training and then maybe you told your advocate, let's go to the Cooperative Tribunal. And then he's telling you, let's go to court. This court is very near. No matter how near the court is, does it have jurisdiction? If it doesn't, it falls. Number one, the original jurisdiction, exclusive jurisdiction to cooperative matters belongs to the Cooperative Tribunal. Let your advocate, we've even had some other very big cases where advocates feel that this dispute is very big. I want to take it to the High Court. You go there, the case is just dismissed. Someone in the court section 76, they say, the judge does not have jurisdiction, and your case laws is always, the law will always relinquish them and say, you don't have jurisdiction to do that, because under Section 82 and 83, a dispute that has already been dealt with at the Cooperative Tribunal, it will go to the High Court. And to the High Court, what does the law say? The appeal that is being filed there, it will be final in nature. So you cannot start with the appeal and then now say you'll go back. No, you need to follow the procedure. Number two, your dispute will not be dismissed because it has been filed in Nairobi and maybe you are a Nyeri resident. But now that I've told you Safaricom is resident in Nairobi, or rather has its head office in Nairobi, there will always be less stringent in terms of where you will file. Even if you file it in Kakamega Tribunal, you file it in Nairobi Tribunal, Nyeri, Mombasa, it will always be transferred. But it cannot be transferred from a civil magistrate court into the tribunal. That one members need to know very well. So you are aggrieved. Where do you go? I need to go to the Cooperative Tribunal. Where is the Cooperative Tribunal? The Cooperative Tribunal is located at Reinsurance Plaza, where 11th floor. If you need information, if you have not been able to go to the Sacco, then you need to go to that tribunal, ask them what you need to know. And then we are going to the roles of the Cooperative Tribunal. Of course, for the roles, generally what they need to do, or what they do, is to hear members' claims. Members' claims include those election petitions. Election petition, this I'm not talking about the election petition for members of parliament, no. There are other disputes which are, of course, they're not purview for this discussion. Maybe the issue about management, the Sacco will hear that, the tribunal will hear that. The issue about refunds, there's some of the Saccos which have already gone down or gone under. You know about them, it's public domain. If you have such like a dispute, you'll go there. You have loan guarantee or guarantors disputes. You've guaranteed someone, he's refused to pay, even after your shares have already been deducted, he's refused to pay you. You have a right in law. Equity will not suffer a wrong without a remedy. You go to the court, tell them I guaranteed person XYZ, they refuse to pay me, or they have refused to refund me. The court will enter judgment in your favor, if that there is evidence. So you need to make sure, and what we started with, do you have documents? But even if you don't have documents, you have a right to go to your Sacco. The Sacco will give you documents. You need the Sacco bylaws, you need the credit policy, you need the any other document that you need. The Constitution, you can download it. So that information that when you're applying the loan, and that's why I was telling you from the instance when we started, is you need to apply for the loan. Make sure that all this information you have, you never know. People don't default. They don't default in terms of their loans because they want. Sometimes it's just about it's an accident. Sometimes I would call it an accident. That's why most of the advocates, you always find them. Sometimes you'd be representing a defaulter. Sometimes you are representing the guarantor. Sometimes you are representing the Sacco. So sometimes I would say the Sacco or a default is by an accident. But for that person who has refused to pay completely, it's an act of commission because he is intended for it to do that. So the most important issue, or the cases that you'll just be looking at, you'll be looking at the share refund, guarantees, charges, management issues, election petitions, interlocutory application. For any interlocutory application is that before the case is heard, you want some immediate or rather very urgent reliefs. So before I wait for that 1 year that the case might be heard, I want to go to court and then tell the court that, look, this person has this X amount of whatever income or whatever is happening. I want a relief that can help me so that they can not, instead of continuing to burden me with all this person's amount be held. And there are always very many ways on how it can always be structured. This one you'll always find, or by the time you are going at the tribunal, they will always tell you, and sometimes don't be very or in a rush to go for interlocutory application, because with our experience at the cooperative tribunal, those interlocutory applications will waste a lot of time. You'll take maybe six months to and above just looking for that. Sometimes if you have a dispute, just file for the dispute, go for the main hearing case or details, and then after that you will proceed. I think we can move to the next slide. And then the categories of the dispute that can be dealt at the tribunal, you need to understand that you can look, I've already said that, it can be a dispute between members. If it's a dispute between members of the same Sacco. So if a dispute is not falling within members of the same Sacco, this tribunal does not have jurisdiction. Now, I've said jurisdiction is the power in common language, is the power that the court has been bestowed by an act of parliament to deal with certain disputes. So that if this court is only dealing with land matters, I cannot take there a criminal matter. If this magistrate has been designated to handle this XYZ of disputes, I cannot now take my cases for maybe, let's say, family, children, custody, and all that. So for each and every magistrate and cadre of court, they have their respective powers, or rather mandate, cut out in law. And the most important thing you need to understand, and I need members to be very keen when we are handling the issue of jurisdiction, because very many cases have suffered defeat because of jurisdiction alone. You go to the wrong forum, done. And once you're done, the filing fees and everything, you lose it. And then the other advocate you've been suing, actually even the loan defaulter who you sued, you are supposed to pay the advocate. So you will suffer defeat in two ways. You've gone to the wrong place, you are paying even the advocate for that default. Number two, there are also other disputes which relate to past members or deceased members. You might be having a members, of course, we are human beings. Sometimes you are a member is passes away and any other thing. You will also have a right as a nominee to that effect or to that extent. Of course, the Sacco has. There are instances where the Sacco is not in a position to verify who you are. You need to go to court. Of course, through succession, after succession for a grant, and then after that, you will have to go back and then now to the cooperative tribunal just to ask for what was due to yours, or maybe your parent or maybe your spouse had shares over there, then that dispute will still fall within that. Then there are also other disputes between societies and cooperative societies among themselves that tribunal will also have a jurisdiction to handle such claims. Can we go to the next slide? And then the procedure at the tribunal, I'll be very brief to handle it. The most important thing you need to know that before you go to the tribunal, I've talked about the issue of jurisdiction, which is very important. In law, they say jurisdiction is everything. So if you don't have it, you cannot exercise anything. So you need to make sure that that court that you're attending or that court that you're going to has jurisdiction. And I've already told you, if you are in doubt and it's a Sacco tribunal or it's a Sacco issue, just walk to the tribunal. You'll always be safe. There, at least you are on the right of the law, which is correct. It will always be easier for you even to walk out from that tribunal, unlike walking out from the normal civil courts. It will always be very, very hefty in terms of even filing fees and all that. And for your information, you need to ensure that you're not just filing any frivolous case. You go to court, you lose a case, you pay the other advocate costs or the other person costs. So you need to ensure that before you file any case, you are appraised of that. So the most important document that you're supposed to file when you're filing any claim in court, there is something called a statement of claim. There is a verifying affidavit. After that, there is a witness statement, there is a list of documents, there are summons, and then any other attendant document that you want, you'll have to attach it to that claim. So at the tribunal, it's always called a statement of claim. So most advocates will always find, for those who are not practicing at the cooperative tribunal, they will always file a document called a plaint. But a plaint is that which is used in the normal civil courts, be it in high court or the chief magistrate courts. But when you're coming at the cooperative tribunal, you're filing a statement of claim. And why is it called a statement of claim? This is a claim. This is not a dispute. This is not a dispute that we want to say it's a suit, or let me use the word suit instead of a dispute. Yes, it's a dispute because maybe someone has refused to pay or all that. But it's a claim that I guaranteed person X amount of money, my shares have been deducted, and they have refused to pay me. So what you are doing, you're simply claiming. It's called a statement of claim and the other attendant documents. When you are even representing yourself to that extent, you need to make sure that your documents are properly done. So even in a situation where you are going to represent yourself, and the tribunal allows members, even lay persons, to represent themselves. And never fear to go to court because you don't have an advocate. Where you don't have an advocate and you feel like your claim, maybe it's for 40,000 or even 20,000, that is still money, because for you, it might not, for another person, it might not be a lot of money. And that's why maybe they have defaulted in and they have refused to pay you. But for you, it's money that it's a hard-earned money. So you need to make sure that you're following up. Just go at the Cooperative Tribunal, they will tell you what you are supposed to do. Or in the alternative, you can always even reach to the Sacco and ask them, what am I supposed to do? The Sacco should be in a position to let you know, or rather even give you templates, or if indeed the Sacco can reach out and they will tell you, we'll give you this template A, B, and C, and then go and draft your document and then go to court. You will be called for a hearing. It's not complicated as the normal courts would be. That's why it's a tribunal. The tribunal is more of an inquisitorial nature, because even some of the orders would be given, they would extend even to the issue of production of documents. So that if indeed you want to go to court, let's say, for instance, you've gone to court, you don't have documents. You can go to court and tell the court that, look, I'm filing these documents, but person A, B, and C has refused to give me this and this document. So I want them to release this document. The tribunal will give those orders for those production of that document. So the most important thing, once those documents have already been filed, the maximum filing fees of any claim, it is 70,000. The supporting documentation will come to 1,000 or 2,000, depending with the document that we'll be filing. For every document that is supporting, 10 shillings per document. So it depends. I cannot tell you with certainty that this is what will happen. And the principle of calculating how much filing fees would be, if for those who can write it down, is the principal amount. After the principal amount, let's say you guaranteed someone principal amount of 500,000 minus 6,000. Once you get that, you multiply by 0.02 times plus. After multiplying by 0.02, you now plus 880 plus 100. It's a formula that the judiciary has come up with, but this one is being used at the tribunal just to make sure that they're assessing the amount you'll pay. Sometimes people are always confused on what that means. Filing fees is money that goes to the judiciary, and judiciary, I would say, let me say in simple terms, this is money that will be collected by the government. It's a form of tax for me, if you would ask me, because this is not money that the judiciary will refund you. No, you will only be refunded this money by that person you've sued. So if you've sued a defaulter, it is the defaulter who will repay you that cost. It's called costs. So let's say you're filing a claim of more than 1.5 million at the tribunal. You'll be told filing fees is 70,000. So by the time you are already successful in your case, that 70,000 will be reimbursed, or rather will be part and parcel of the costs which you would have already incurred. That is number one. Number two, that person who you already sued will also have a time to respond to your case. They will have 15 days once you have already served them with the summons. What normally happens, the 15 days, of course, those are summons. You are supposed to serve them in person. But after the corona period, of course, the law was changed. Right now, someone can serve you through email, registered email, or rather your last known email address. Of course, previously would say postal address. But right now, people are just serving others on email. It's allowed under the rules. And then you can also be served under WhatsApp, through WhatsApp. Provided you have two blue ticks, it's okay. And I know some people will always be a bit now smart. They would change the blue ticks to the other white ones, or wherever I'd call them. And what advocates have already gone back and seen is you'd always go to the settings, and I would always check if you've seen the message. I will take a screenshot, and just to ensure that that service has been done, I'll send you some small monies, even if it's 10 shillings or 20 shillings, just to ensure that the money you've sent to a guy, Chimei is the respondent. He has two blue ticks, I will do that. My process, a licensed process server, what you will have to do, you will have file a document called a return of service or an affidavit of service saying that I sent this person X money on, or I sent this person X the documents on WhatsApp. There are 2 blue ticks. This is a screenshot. Just to ensure that the person who was served is Hagai Chimei, I also sent them 10 shillings, which returned an M-Pesa message saying it's Hagai Chimei. Once that has been filed in court, that is effective service. So don't refuse any document that you are served either on WhatsApp or email or any other form. Take those documents, look for legal advice. It's always necessary, because if you don't show up in court after those 15 days, now the new rule that the Sacco has done, then the tribunal has brought into place is after those 15 days lapses, they will give you a leeway of another 30 days. So after these 30 days, they will just enter judgment. No hearing, no nothing. They will look at the documents. Are the documents okay? Yes. Is there a response? No. Judgment will be entered after those 30 days. But if this person comes and then responds, then now you'll take a mention to confirm everyone is ready for the hearing, and then a hearing date will be given. I cannot tell members when the hearing date will be given, because that diary is always for the judiciary. Sometimes we would even want us, or we would want to bring that diary close to the dates, but sometimes when they also don't have quorum, it will never be had. So that is the most important thing that you need to understand. And what happens even after that, or after you file that case, once judgment has already been entered in your favor or in favor of any other person, the most important thing that this judgment or judgment debtor is supposed to do, or creditor is supposed to do, is now to follow up. You can follow up in many ways. You can do warrants of arrest. You can arrest that person, take them to civil jail. When you take them to civil jail, you pay for them 1,800 per month for them to be in civil jail. Of course, in Kenya, you always need to know that before you arrest someone, you have to use the police. Civil jail is one of it. Number 2, you can attach his property. Property includes even shares. You can even go back and attach his shares. But I know by the time you are going to court, he no longer have shares because he refused to pay. You can go for his immovable property, which is land, maybe, or something of that sort, houses and any property. You can even go for movable property, which include even these vehicles and all that. So the most important thing, or if he's employed, you can attach his salary, so that what the court will say, salary person XYZ be deposited always into this other person's account. And the moment any human resource practitioner has been served with that, they will always have to comply. They refuse to comply, you will also have to take them to court for failure to do what? To obey court orders. And I think now we can go to the last slide before we can take a few questions. Now, what are the outcomes for claims before the tribunal? There are a number of outcomes, but the main are 2. Your claim is granted, you have a judgment in your favor, or your claim is dismissed with cost or without costs. You could have filed a frivolous claim, maybe saying you have not been, you already paid your loan, or these and these have not been done, but this tribunal will assess the strength of your evidence, and you'll always be heard. So that is a court of law. But if you are not satisfied with that decision, you have a right to go and appeal that decision at the High Court. So there are two ways. It's either you have a claim which will be granted, and either party can appeal that decision. You could have sued someone maybe for 500,000. Maybe the court, in a punitive way, slaps them with other costs, with other things that were not necessary or wherever. So whoever is dissatisfied with that decision can always go to the High Court for that. Or in the alternative, even during or in the process of resolving this dispute at the tribunal, there are some of those loan defaulters. Once you serve them with the summons, they will always now come. Oh, okay, person XYZ, your friend, let's sit down and then talk. The court will always allow that. So if you have a settlement before the case is terminated, you'll always write that settlement. It's called a consent. Just you write it, whichever form, even if it's on a full scap, that one doesn't take any form. Provided both of you signed, and then you go and take a mention at the tribunal. That one you don't have to wait for the dates that the court will give. You can even take a date within 7 days, and the court will always allow. because this is a matter that it's allowing you to mediate between yourselves or negotiate between yourselves and then settle these deals at the earliest. So if you go with a consent that you've already agreed and you have already repaid or something of that sort, the court will always allow you to do that. Or in some other instances, the court can even have partial awards. Let's say, for instance, you're going to the tribunal, and then let's say maybe it's a Sacco which is recovering its loan. The Sacco says this person XYZ has defaulted to the extent of the loan was for 1 million, he's refused to pay 500,000. And once you go to court, the court is now the Sacco is now claiming this 500,000 together with the interest and penalties and whichever claim they might have. So once this person comes and puts in a response, if they do not deny that they owe this 500,000, the court will first do a partial judgment or a partial decision or a partial award. Say, for this amount that has not been disputed, we enter judgment. And once a judgment has been entered, you have an obligation to pay. If not, auctioneers might be sent your way. So the court can go two ways. It can give you a partial judgment, or you'll have to wait for that whole claim to be heard on merits. But if the person who has been served with the document does not show up, then a final judgment will be entered on the whole claim. So, and any party who is dissatisfied with any decision of that tribunal, you always have leave to go and appeal at the High Court. High Court is just the normal civil court, but under the Act, that is now the appellate court in terms of the tribunal matters. So I think that would be my presentation for the day. I don't know what the program manager will say, but I can take a few questions. But even before that, I think as we'll also be proceeding to this, I'm not opposed to anyone reaching out through the Sacco asking any question. I understand we are many, so sometimes I might not take all the questions, but for anyone who feels that they want legal advice, anything, I work together with my other partners. You can always send your questions through the Sacco, and then the Sacco will always tell me person X has asked about this. We will always advise you. So don't worry about time for today. If you have any questions, I think Njeri can take all the questions. And Njeri, as we had talked, I can answer them in a format that allows them to understand. But if not, if you have a follow-up, just ask. At least for that, I said when I'm doing with the Sacco, members will get that free advice for that. But when you want to go to court, as a guarantor, you have the obligation to go for the market, look for your own advocate, and then, yes. But if you have any questions, you can come to us. If you want anything you for concern, just come to us and then we ask. So, Jerry, you can take, yeah.
Thank you so much, Chime. You have given us a lot to digest, because that was quite an informative session. And the questions are so many, and the team has been doing a very great job at answering them live. But I have a question of my own before we get started with the questions that have from the Q&A. Chime, in the event of the loanee passing, in the event he dies, what does the tribunal say? Because you see, this man has his savings, Sacco savings and everything. So I have guaranteed somebody and they have passed on. I know you did say that I am the security of the loan as a guarantor, but in the event this person passes on, what happens?
Now, the most important thing, this borrower, let's use the term borrower or the loanee for the sake of all the members. This person passes away. The most important thing is you've taken this loan. First, you're asking, does the Sacco have any insurance against this loan? That is the most important thing you're asking. So if there is an insurance for that loan, the insurance is supposed to take care of that loan or the remainder of that loan. Right? Number one. Number two, if that does not exist, where does it leave the guarantors? Because I see that question is in terms of the guarantors. Now, the guarantors have an obligation in law, just the general law, not even the cooperative's law. You are supposed to go to court. You have to sue the estate of the deceased, that person who's taken the loan. Yes, you don't die with your obligations, Jen. So you are there. You have assets. You have motor vehicles and all that. The Sacco can go for that. The estate, it's called the estate because you are no longer alive. and any other person who has a claim against that person can go for that. But it's always a bit a prolonged procedure under the Succession Act for you to go to that. So you can sue the late person's estate or the deceased person's family property. Estate means together with all the property and anything that they own.
Yeah. Okay, so it will be quite a tedious process to be able to reclaim that, I should think.
Correct. And that's most of the time you will always have to make sure when the guarantors, I'm answering the guarantor's perspective. When the guarantors are guaranteeing someone, it's always a question for them to ask. I know that those circles which will take insurance for their loans. There are those which do not take because we represent a number of them. So you're not in a situation just to say that, okay, don't assume, and this is for the guarantors, don't assume anything. Ask all those questions like Ghana is asking right now. You are asking, do we have this? What happens after this? The Sacco should be in a position to tell you, because now that is an administrative position. I cannot tell you, okay, Safaricom Sacco has taken this or the other Sacco has done this. Don't assume. So that even if you've done an email and I've told you, yes, we have an insurance, proceed. If he passes away, you go back to your email, say, you told me this. Now don't come back to me. He's passed away, he's done, go to the insurance. You understand? Yes.
Yeah. I can see Joyce is following up with a question on chat. In what instance would the loan not be insured? So it's not automatic that all the loans of Sacco are insured.
It's not. And the truth, Anjeri, the truth is compliance, it's an individual or rather at an administrative level. Like today, as an advocate, most of the time, and I would also sensitize members when they're also looking for advocates. For God's sake, just go on Google and look for this advocate. Does he have an insurance policy? You need to have an insurance policy even for your practice. Like ourselves, even when you are doing work for Safaricom, you'll always be asked for that, right? But for this loanee or for this Sacco, you want to assume that they have. Don't assume. Ask. Do they have? If not, then don't do this and this and that. So it's a bit administrative. So I cannot tell you it's a must for this. Yes, it's a must. Yes, people must pay taxes, but everyone pays. Not everyone pays. Sometimes there are those who declare and that. So don't assume. Ask. So I'll tell you that those circles which do it and there are those who do not, just like for the commercial banks. There are those who will do, and sometimes you'd even imagine maybe they have done, and maybe your paper was just left on the table. And if it happens that your paper was not remitted to the insurance, what happens? The law now, you'll have to follow up with yourself. Your document was left on the table. It was never like you get you get in an accident, you don't report. It's done. It's done. Yes.
I have there's a very lengthy question here from Odongo Olumbe, which was already answered, but maybe you can answer it live. How can Sacco assist in case whereby one defaults on his loan and I, as the guarantor, is being forced to pay the loan despite the defaulter having a car which he's using as an online taxi? Does Sacco have powers to repossess assets, in this case a car, to recover the loan?
Thank you, Odongo, for that question.
Also, I recently got a communication from Sacco of risk of being listed on CRB because of the same aforementioned defaulter loan. We as guarantors have 5 different suits in the Cooperative Tribunal and even small claims court, but still Sacco is threatening to list us on CRB because of the defaulter loan, which in my opinion is unlawful, isn't it?
Now let's go back to the question. I think now I think even that member has suffered one blow, and I think the earlier the better. Small claims does not have jurisdiction. My brother, my sister, please walk away from that court. It does not have jurisdiction. Your case will be dismissed tomorrow morning. Don't just go and withdraw before even just go and withdraw it. The court does not, small claims does not have jurisdiction. Small claims only deals with civil disputes together and commercial disputes, which are ranging from 10,000 to 1 million. Any amount more than 1 million, it does not have dispute. But I've already told you, under Section 76 of the Cooperatives Act, this Sacco, this tribunal is the one which is to do this. Most of the time, even they are called adjudicators. They will just look at that at the small claim and tell you, look, this we don't have jurisdiction. Go to the Cooperative Tribunal. I think that one, I don't know if it was for Odongo. And then what is supposed to be done, and the issue where someone is, or the defaulter, I call them defaulter once they have already refused to pay, or the Sacco member or the loanee has refused to pay. You have already been deducted your shares, and you can see them with the with the taxes online and living lavishly wherever, and you are suffering wherever you'll be. The Sacco can help, yes. Safaricom has been doing even this, but remember, the Sacco does not have that obligation to do it on your behalf. It is you who has been aggrieved who is supposed to do it. For those ones which the Sacco has been doing and following up on behalf of the guarantors, the Sacco has been filing those cases and you'll always be informed. But you also look at it this way. The Sacco does not also have these facilities or funds to be filing for every guarantor that happens, because then what is even the utility of that guarantor? If indeed I cannot recover from your shares, then it would be logic that I'm even asking for that guarantor's shares. So the Sacco, yes, has been doing it, he's been doing it, but I cannot tell you that the Sacco has the capacity to do all of them, because the level of defaulters has risen after the COVID-19. And it's very unfortunate that I think even the Sacco, in terms of even the facilities, because you don't want to assume that taking other people's money, paying advocates to go and look for other people's money, and this person does not want to pay, and I already have your shares. So which is the easiest thing? You are the one who guaranteed, and I've already told you the rights and duties. It's your shares first to be held, so that the other members want to earn dividends. In as much as you are aggrieved, someone's money was used, and that someone is waiting for dividends. So with that default, we will not be waiting for those defaulters. These people, they also want loans. If this money goes for legal, it means now it's no longer even a cooperative society. People will not be able to take loans. So the Sacco, yes, can help. And it has been helping actually in terms of even filing some of those cases that even, I think some of them, there are those which are started with those big loans, which indeed they really messed up some of the members. And I think the Sacco has been doing that. If yours is one of them, I think, Jerry, you can answer that, because I don't know each respective member, but each member has that obligation to follow up. And then on the issue of being listed, I think that one I talked about it when I was following up. Now, you see that we are going back to the rights and duties. So it's the duty of that Sacco to list you, because that is one of the mechanisms that they want also to make sure that, look, you have defaulted, or you have not paid your loans. So you should not be sitting pretty and then going to take other loans with other Saccos or any other facilities just as if nothing happened. You are messing other members' lives. And I can tell you, having practiced at the Cooperative Tribunal, very many members' lives are always messed up because of this guarantee issue. To guarantee your friend, even family member, they refuse just to pay. And you go even to their family, they are living largely and they have refused to pay. But now you look for, you're the one now suffering. You have to go pay an advocate. You will have to leave work, go and do all these things. So it's unfortunate, but that is the sad truth. It's unfortunate, but that's the sad truth. Yeah.
I hear you. We'll just probably take one more question. I don't know how the front of house is saying. One more question? Yes. So Philemon on chat is saying, after implementation of the defaulter loan deduction by Sacco, what happens when a person I had guaranteed pays full amount eventually? Can I get my refund of the amount which had been deducted? Is this a tribunal? Does he have to go to the tribunal? Or what happens when this happened? What is the way
I think
forward?
I can answer that, but I think Jerry, even that one you can answer. I think it's more of general question. But yes, if he comes and pays, and then why not? You are supposed to be refunded your shares. But you see, even if you are refunded your shares, maybe it's even after 2 or 3 years, you have not been earning dividends on it. Yes, If he comes and pays, you'll be refunded your share. There's no problem. They'll always just be credited back to your account. But there is one thing that you'll fail to understand. You have not been earning dividends on that amount. So sometimes it's a duty for you to, it's really, it will rain heavily on you for being a good person. But that does not mean that you should not be a good person. Help each members so that it's a society, and that is part and parcel of the principles which regulate societies and circles, that it's a cooperative member. You work as a team. So, but make sure that the people you are guaranteeing or you are doing all these things together, at least you are people that you know each other, and then that people who will not let you down. So, yes, it can. Yes.
Okay, ladies and gentlemen who are viewing, you know that without a doubt, ignorance is not a defense. So you have been educated by Chimei as far as your requirements as a guarantor. And what was the parting shot for me is that you are the security. Once you become a guarantor, you are the security for that loan. That statement hit me hard. So Chimei, any last comments as we are winding up?
I think, Anjali, thank you for inviting me for this. I think I also learn. I learn every day, because even through the interaction and preparing this presentation, coming to present, I learn. So the most important thing, let us as members, I know that those people who borrow and those who take loans, actually, SACCOs, the most important thing that can help a member grow is the SACCO loans. Even personally, as an advocate, I also take loans. So no one, even any economy, I think even just to veer off kidogo, our other loan has already been approved by the World Bank. So we need loans. Even as a country, you're borrowing loans. You need loans to grow, because you can't rely on your salary forever. But the most important thing, and for my parting shot, is if any member feels like he needs legal advice, let them reach out to Safaricom Sacco. Njeri, I think I can give them a window of around 90 days. I could answer any questions. Pro bono, free of charge. Don't fail. If anyone wants to talk to us, reach out to us. We'll advise you free of charge. But when it goes to court, then you'll with that's another one. But just for advice, I will dish out free of charge. Don't worry about that. So thank you for this session.
So as you've heard, Chimei, 90 days. If you have any questions about Safaricom Sacco or about this particular event right now, the education that you have gotten as far as the role of a cooperative tribunal, as a guarantor, as a loanee, if you have any questions, please feel free to reach us on sacco@safaricom.co.ke. Okay, sacco@safaricom.co.ke, and we'll be happy to answer any question. So as they say, feedback is the breakfast of champions. We have come to the end of this session. So as you're winding up this webinar, there'll be about a 15-second window for you to fill up a survey. We know there's a lot of information you didn't know. You didn't know how a guarantor is affected as far as when you're coming to guarantee somebody on a loan. You've seen how a lot of responsibilities fall upon you. So if you have anything you're interested in us discussing during this educative monthly webinars, that will be the time in that 15-second window. So fill up that survey, and we'll be able to serve you better. Thank you so much for your time. I know kesho ni holiday, so we have to get out of here so that the holiday begins. And have a great evening. Bye.
Because no one can predict when emergencies happen, Safaricom Sacco is taking proactive steps to further cushion its members by reducing the interest rates from 2% per month to 1% per month. You can still access a maximum of 3 times your savings and a maximum of 1 million Kenya shillings with a 12-month repayment period. We continue to help you remain supercharged financially with our super premium loan, which is now called Premium Loan. We have introduced lower interest rates of 12% per annum from 14% per annum with a maximum loan amount of 10 million Kenya shillings and a new repayment period of 48 months. You've been saving up well and are now looking to top up and get that loan amount that fits your needs. You can apply for our deposit boosting product and qualify for a loan. The waiting period is only 2 months, and if you wish to boost your deposit and borrow immediately, this will attract a 5% upfront interest on the boosted amount. And if you have just joined us as a check-off basis member at Safaricom Sacco, you can apply for our Karibu loan. Access 3 times the deposit at 1% per annum and pay it within 12 months. The loan amount will be added to your savings to attract an interest of 5% recovered from the loan. A third of the loan pays for shares and is retained as deposits. For the children's account, you can now self-guarantee a loan using your junior savings account. Funds will not be accessed until completion of the loan.